Good afternoon, everyone. My name is Jamie Bernstein. I have the honor of serving as the Executive Director of the Children's Commission. And on behalf of the Children's Commission, I would like to welcome all of you to today's webinar entitled 89th Regular Legislative Session Update. A PDF copy of the PowerPoint presentation will be made available for download on the Children's Commission On-Demand Training and MCLE webpage. For those of you watching this presentation live, the Q&A feature is available for this webinar, and questions will be addressed at the end of the presentation if time allows. Additionally, the MCLE course number information will be provided at the end of the presentation. If you're watching this webinar as a replay, you can email cctraining@txcourts.gov for MCLE self-reporting information. And it's now my pleasure to turn the presentation over to Brenda Kinsler.
Good afternoon. My name is Brenda Kinsler, and I'm a staff attorney with the Texas Children's Commission, and I'm honored to provide you with this presentation. Let's begin. As Jamie mentioned, this presentation is entitled the 89th Regular Legislative Session Update. Before we begin, I would just would like to just make sure that everybody knows that the bills that are listed in this update, they're not exhaustive of all the bills passed in the 89th regular legislative session, but represents the Children's Commission's best efforts to identify legislation most relevant to child welfare. As well as the material in this update should not be construed as an advisory or ruling by or from the Supreme Court of Texas or any other court on specific cases or legal issues. This update is solely intended to address the improvement of the law, the legal system, and the administration of justice. Some of the common terms and acronyms that we're going to be using are presented on this particular slide, and we'll go over them very quickly. Again, this is not exhaustive list of the terms that will be used, but these are probably the main ones that we'll be using throughout this presentation. So the first is, of course, DFPS, which is the Department of Family and Protective Services, HHSC, which is the Health and Human Services Commission, PMC, which means Permanent Managing Conservatorship, a SAPSR, which means a suit affecting the parent-child relationship, SSCC, which is a single source continuum contractor, TFC references the Texas Family Code, TMC is Temporary Managing Conservatorship. With that, let's begin. Let's dig into some of the House bills that passed during the 89th legislative section. We will begin with HB 109 by Representative Rose. This has an effective date of September 1st, 2025, and it amends sections of the Health and Safety Code, specifically 551.007C with new language, and 554.001A that was amended, and 554.002, which was also amended. And what it does is it authorizes HHSC to award one-time grants contingent on legislative appropriation for the construction, expansion, or operation of inpatient mental health centers. It broadens the authority of DSHS, which DSHS means the Department of State Health Services, to designate multiple state facilities as residential treatment facilities, including children in the conservatorship of DFPS. It also clarifies that children placed at these facilities may receive educational services only with prior approval from the local school district superintendent. The next bill we're going to look at is House Bill 116 by Representative Dutton, and it has an effective date of September 1st, 2025. This amends Texas Family Code 161.001B10. And what it does is it removes the ground for termination that relates to a parent's failure to comply with the specific provisions of a court order that is specifically established the actions necessary for the parent to obtain the return of the child who's been in the PMC or TMC of DFPS for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for abuse or neglect. So it's important for practitioners to understand that though the O ground was removed, the other grounds were renumbered after the removal of this particular ground for termination. So for example, the P ground, which was the use of controlled substance in an endangering manner, is now the O ground, and so forth and so on. This is going to apply to a suit that is pending in a trial court on September 1st, 2025, or is filed on or after September 1st, 2025. So it applies to a suit that is pending or is filed after the effective date. The next bill we're going to look at is House Bill 140 by Representative Noble, and it has an effective date of September 1, 2025. And it repeals Human Resource Code Section 40.021. And what it does is it abolishes the Family and Protective Services Council, and that's going to be effective September 1, 2026, the repeal. It also adds new language to Human Resources Code Section 40.031. And what it does is it establishes the Child Protective Investigations Advisory Committee to improve accuracy and consistency in DFPS investigations of abuse, neglect, and exploitation. The committee will advises and makes recommendations to DFPS on policies and procedures, training, due process, engagement, interagency coordination, compliance, and data-driven practices. It also adds new language, again, to 40.31 of the Human Resources Code. And some key features of this Child Protective Investigations Advisory Committee is that it's going to be comprised of public appointees with relevant expertise. DFPS staff are non-voting members. Members with conflicts must recuse themselves from certain deliberations. They will meet quarterly, may review anonymized case samples in closed session. They will submit an annual report to state leadership with data, findings, and recommendations, and all case-related materials and committee work product are confidential. And this Child Protective Investigations Advisory Committee will expire. This new language, this section, expires on September 1st of 2029. The next bill we're going to look at is HB 166 by Representative Capriglione, and it amends the Penal Code Section 22.041 C-1. And what this does is that in addition to methamphetamine, it expands the types of controlled substances to include those listed in penalty group 1B, for example, fentanyl and derivatives, that when involved in certain conduct, create a legal presumption of endangerment to a child, elderly individual, or disabled individual. This presumption applies in the following circumstances. There's a manufacture, possession, or introduction of the substance in the presence of a child, elderly individual, or disabled individual. If there's a positive test of a child, elderly individual, or disabled individual combined with proximity or accessibility to the substance, or illegal personal use, such as injection, ingestion, and inhalation of the substance. And this legal presumption is going to apply only to an offense committed on or after September 1st, 2025. An offense was committed before September 1st, 2025, if any element of the offense occurred before that date. The next bill we're going to look at is HB 451 by Representative Thompson, and it has an effective date of September 1st of 2025. This amends Family Code Section 266.102A, and it adds a requirement to screen children within 45 days of entering DFPS conservatorship for risk of commercial sexual exploitation using a validated, evidence-informed tool selected by the Office of the Governor Child Sex Trafficking Prevention Unit if age-based guidelines or specific concerns warrant the screening. Note that DFPS is only required to implement this provision if funding is appropriated by the legislature. It also amends Family Code Section 221.003B, which adds a requirement that prior to disposition of a child's case, the risks and needs assessments for each child under the jurisdiction of juvenile probation include a screening for risk of commercial sexual exploitation using the tools selected by the Office of the Governor Child Sex Trafficking Prevention Unit. Next, we have HB 694 by Representative Gervin Hawkins, and it has an effective date of September 1st, 2025. And it amends Family Code Section 264.018D through G. And what this does is it requires DFPS to make reasonable efforts to notify the parent's attorney if the parent is represented by an attorney within 24 hours of certain events. For example, a new psychiatric medication, and it adds a placement change as an additional event that requires this notice. It requires DFPS to provide at least 48 hours advance notice to the parent's attorney, again, if the parent is represented by an attorney, before changing the residential child care facility. It changes the timeline for DFPS to provide notice from 10 days to 48 hours after DFPS becomes aware of a significant event. And it adds the parent's attorney if the parent is represented by an attorney to the list of individuals to be notified. If a hearing occurs within that 48-hour time period, DFPS must provide notice at that hearing. It adds new language. HB 694 adds new language to Family Code 264.018H-1. And what it says is that notwithstanding subsection H, which subsection H provides a list of reasons why or circumstances under which the department would not be required to provide notice to a parent, right? So, but this, notwithstanding that subsection, it requires DFPS to notify a parent's attorney if the parent is represented if DFPS cannot locate the parent or the child is in the PMC of DFPS and the parent has not participated in the child's case for at least 6 months despite DFPS's engagement efforts to involve the parents. It adds new language to Family Code Section 264.018M by providing that DFPS must document all notifications and attempted notifications in the child's case record. HB 742 by Representative Thompson, with an effective date of September 1st, 2025, adds new language to the Health and Safety Code, sections 763.001 through 003. And it requires first responders, excluding peace officers and volunteers, to complete a human trafficking training course approved by the Executive Commissioner of HHSC, and it requires at least one no-cost training option to be available. It mandates public posting of approved courses on HHSC's website. We also see new language in Health and Safety Code sections 241.011, 241.0115, 254.161, and 254.162, which updates signage requirements in hospital, emergency departments, and freestanding emergency medical care facilities. It also prohibits hospitals and freestanding emergency medical facilities from disciplining, retaliating against, or discriminating against employees who report suspected human trafficking in good faith to appropriate authorities. It also just requires or directs HHSC to improve and publish the free courses and to adopt rules to implement this new chapter. HB 793 by Representative Thompson, It has an effective date of September 1st, 2025. And it amends Family Code Section 82.011. It changes the court's authority from discretionary, the may, to the mandatory, shall, in shielding the applicant's mailing address and county of residence upon request by an applicant for a protective order. It also amends and adds new language to Family Code Section 85.007A, in that it changes the court's authority again from may to shall in excluding the address, county of residence, phone number, and certain locations, for example, the child's school, from a protective order upon request by the protected person, or it now adds an adult family or household member. It requires the court to inform each protected person or adult family or household member of this right during the hearing on an application for a protective order and directly ask whether they want their information excluded. And this is going to apply to an application for a protective order that is pending on September 1st, 2025, or that is filed on or after September 1st, 2025. HB 793 also adds new language to Family Code Section 87.004A-1 in that it requires the court, upon request by a protected person, to keep a changed address or telephone number confidential in the notification sent to the respondent. The court must order the clerk to maintain the information in a confidential record consistent with prior procedures under Texas Family Code, Section 85.007. For the mailing address to be withheld, the applicant must provide it to the court or designate someone to receive official court documents on their behalf and disclose the designated person's address. And this is going to apply to an application for a protective order that is pending on September 1st, 2025, or filed on or after September 1st of 2025. Next, we're going to look at HB 908 by Representative Spiller, and it has an effective date of September 1, 2025. And it amends the Code of Criminal Procedure, Article 63.00905A, by adding new requirements for law enforcement to enter missing child reports into the National Center for Missing and Exploited Children with detailed identifying information within 2 hours. And it adds the National Center for Missing and Exploited Children to the requirements for agencies to inform the reporting party that the child's information will be submitted to the listed databases and agencies. HB 1106 by Representative Shaheen. It has an effective date of September 1, 2025, and it both adds new language and amends Family Code Section 261.0011A. And what it does is it changes definitions of abuse and neglect to exclude a caregiver's refusal to affirm a child's perception of the child's gender, including a refusal to use a child's preferred name or pronouns, regardless of whether the child's name has been legally changed, or to affirm a child's express sexual orientation. HB 1151 by Representative Hull has an effective date of September 1, 2025, and it adds new language to Family Code Section 161.001C8. It adds to the lists of evidence that does not alone constitute clear and convincing evidence sufficient for a court to make a termination finding against a parent. And so what it adds is that a parent's refusal to administer or consent to the administration of a psychotropic medication to the child, or to consent to any other psychiatric or psychological treatment of the child, unless the refusal presents a substantial risk of death, disfigurement, or bodily injury to the child, or results in an observable and material impairment to the growth, development, or functioning of the child. So evidence of this would not constitute clear and convincing evidence sufficient for a court to make a termination finding. Additionally, it also adds new language to 161.001C9, again, adding to the list of evidence that does not constitute clear and convincing evidence sufficient for a court to make a termination finding against a parent, specifically that choosing a recognized alternative healthcare treatment or therapy for the child that could be considered as new, emerging, or non-standard, unless the treatment or therapy presents a substantial risk of death, disfigurement, or bodily injury to the child, or results in an observable and material impairment to the growth, development, or functioning of the child, right? This evidence, unless it presents a substantial risk of death or results in an observable and material impairment, would not constitute clear and convincing evidence sufficient for a court to make a termination finding. And consistent with these additional factors, we see amendments to Family Code, or new language added to Family Code 261.0014B4, which amends the definition of neglect to exclude, again, that refusal to administer or consent to the administration of a psychotropic medication, unless that refusal, again, presents a substantial risk of death or results in an observable and material impairment to the growth, development, or functioning of the child. And remaining consistent, it adds that new language again to 261.0014B5, amending the definition of neglect to exclude the choosing of a recognized alternative healthcare treatment or therapy for the child, unless, again, it presents a substantial risk of death or results in an observable and material impairment to the child. And this is going to apply only to a suit filed by the department on or after September 1, 2025. And again, consistent with that, HB 1151 also amends Family Code Section 262.116A9, which is the removal section, and it adds that DFPS may not take possession of a child based on evidence that the parent, again, refused to administer or consent to the administration of a psychotropic medication, unless those factors exist. Applies only to a suit filed by DFPS on or after September 1, 2025. And we're going to see this again here in Family Code Section 262.116A10. You're going to see that DFPS may not take possession of a child based on evidence that the parent chose a recognized alternative healthcare treatment or therapy for the child that could be considered as new, emerging, or non-standard, unless those factors exist. And it again applies only to a suit filed by DFPS on or after September 1, 2025. All right, moving on to HB 1211 by Representative Lujan, with an effective date of June 20th, 2025. So it is already effective, and it amends the Education Code Section 54.366A by extending the age limit by which an eligible student must enroll in a public institution of higher education to claim the tuition and fee exemption from their 25th birthday, which is what it was, to now their 27th birthday. And this is going to apply beginning with tuition and fees charged for the 2025 fall semester. HB 1403 by Representative Harris. It's effective September 1, 2025, and it's going to add new language to Human Resources Code, Section 42.042 E-6 through E-9. And what this does is it prohibits HHSC, DFPS, and contracted child placing agencies from requiring foster homes to disclose the specific types of firearms present or report changes in firearm types. Any information obtained about firearm types may only be used to confirm whether firearms are present and not for any other purpose. Violations by child placing agencies may result in a civil penalty up to $5,000 per violation, and that would be enforceable by the Texas Attorney General. Firearm information is deemed confidential, and it is exempt from public disclosure. HB 1620 by Representative Leach, which is effective, has an effective date of September 1, 2025. It provides some non-substantive, it's like cleanup provisions. Essentially, for example, Family Code Section 262-101B was reenacted. Initially, it had been enacted during the 88th legislative session, and it was added by two separate bills. And so what this does is it reenacts it under one section here, and this just requires the affidavit under Section A to describe with specificity in a separate section all reasonable efforts consistent with the circumstances and providing for the safety of the child that were made to prevent or eliminate the need for removal of the child. And same thing with Family Code Section 262.105C. Again, it was reenacted. It essentially just reenacts this section that was added by HB 968 and HB 1087 from the 88th legislature. And so it just kind of combines that and makes that change, that cleanup change, again, which relates to the specificity required with regards to reasonable efforts. HB 1734 by Representative Orr, and this has an effective date of September 1, 2025. And this is going to amend Family Code Section 155.207A. And what this does is it revises the requirement that the clerk of the court transferring a proceeding to the proper court to which transfer is made send a copy of the original papers filed in the transferring court and replaces it. So that used to say send a copy of the original papers, and it's now been replaced with a copy of the pleadings in the pending proceeding and any other document specifically requested by a party. So this section is going to apply only to a SAPSR in which an order transferring continuing exclusive jurisdiction to another court is rendered on or after September 1, 2025. HB 1778. Now, this particular bill contains various provisions related to human trafficking, prevention, reporting, and training. It's a very comprehensive bill, so I invite you to read it if you would like to see all of the changes that it makes. So we're going to address some of the parts of this particular bill that are the most relevant to child welfare. And so the first thing we're going to look at is an amendment to Penal Code Section 20A.02B-1. And this is going to provide for an enhanced first-degree felony, which means the punishment would be from 25 to 99 years or life, penalty for human trafficking offenses if any part of the offense occurs within 1,000 feet of school bus stops or designated pickup or drop-off zones, or in a school bus or other school transportation vehicle. So it's adding additional places where if the offense of human trafficking occurs, it would be enhanced to a first-degree felony. And it also adds new language to Penal Code Section 43.032. And it creates a new first-degree felony offense of continuous promotion of prostitution, which requires promotion of prostitution at least twice over 30 plus days. For this particular new offense, the jury must agree that the offenses occurred, but they don't have to agree on the specific acts or the dates. And there's no double prosecution with standard promotion charges for the same victim unless certain exceptions apply. And it applies only to an offense committed on or after September 1 of 2025. HB 1778 also amends the Penal Code Section 43.26D in that it revises the following penalties for possession of child pornography. It would now be a third-degree felony to have in your possession fewer than 10 images. And that's down from 100. It's a second-degree felony to possess 10 to 49 images. And that was previously like 100 to like 499. And it's a first-degree felony if you have 50 plus images or the images are depicting child sexual assault. And that is down from previously it was 500 plus. And this is going to apply only to an offense committed on or after September 1, 2025. Continuing with HB 1778, it amends the Code of Criminal Procedure, Article 12.01, but by allowing indefinite prosecution for failure to stop or report sexual assault or assaultive acts against a child and continuous promotion of prostitution. And it adjusts limitations periods for prosecuting trafficking, child pornography, and offenses against children or disabled individuals. Now, this does not apply if the prosecution of an offense becomes barred by limitation before September 1, 2025. And it also amends Penal Code Section 38.17, which expands the duty to report child abuse to all sexual assaultive acts against children. And it removes the exception for parents. And it increases the penalty to a third-degree felony. And this is going to apply only to an offense committed on or after September 1, 2025. And as it relates to Section 3817, dual prosecution is allowed for overlapping offenses. HB 1973 by Representative Cook, with an effective date of September 1, 2025. It both adds new language and amends Family Code Section 102.008, adding new language to C1 and amending D. And this is going to require a certified copy of the child's birth certificate to be filed under seal with a petition in a suit affecting the parent-child relationship if it is available. If it is not available, the court may request another party to provide it or accept alternative proof of parental identity. All documents must remain confidential, and Title 40 cases are exempted from these requirements. And this is going to apply to a SAPSR filed on or after September 1, 2025. HB 2071 by Representative Hull, with an effective date of September 1, 2025, amends Family Code 261-3017, C-1, by adding a requirement that physicians providing specialty consultations must not have been involved in reviewing the case, including participation on a review team under Family Code 261-312 or a multidisciplinary team under Texas Family Code, Chapter 264, Subchapter E. It adds new language to Family Code, Section 261, 3017, C-3, by requiring DFPS to provide all medical records, radiographs, images, and other documents used in the investigation to the child's parent or legal guardian, or if represented by an attorney, the attorney of the parent or legal guardian, before making a specialty consultation referral. HB 2071 continues with amendments and new language to Family Code Section 261, 3017. D is amended, E1 is new language. And what this provides is that in cases where physicians disagree in the assessment of the causes of a child's injuries or in the presence of a condition, it requires DFPS to provide the parent, legal guardian, or attorney with the names and opinions of the physicians involved, possible conflicting conditions, all assessments of the child, and all related medical records related to the child. It prohibits DFPS, hospitals, and the network from obstructing access to medical records or documents needed for an alternative opinion, including access to the child for purposes of obtaining an alternative or second medical opinion or diagnostic testing. HB 2071 continues with an amendment to Family Code 261, 3175, B, C, and D, in that it prohibits a healthcare practitioner who participates on a review team or multidisciplinary team from conducting a forensic assessment. And it prohibits DFPS from referring a forensic assessment to a physician who was a member of a review team or multidisciplinary team. Clarifies that access for parents, guardians, or attorneys to medical records and documentation should not be restricted when a child abuse network is consulted. Family Code Section 102.003A9 is amended by HB 2350. Now, HB 2350 makes some substantive changes to a lot of the standing provisions, and we're going to start with 102.003A9, and this is by Representative Dutton, and it has an effective date of September 1, 2025. And what this particular amendment does, is that it replaces actual care, control, and possession of a child with exclusive care, control, and possession of a child for at least 6 months, ending not more than 90 days preceding the date of the filing of the petition to establish standing to file suit. And then it adds relative or other designated caregivers and here it's relatives or other designated caregivers of a child placed by DFPS as persons prohibited from establishing standing under this particular provision. And it's going to apply only to a SAPSR filed on or after September 1, 2025. HB 2350 is also amends Family Code Section 102.003A11 in that it repeals the provision that conferred general standing to file suit by a person with whom a child and the child's guardian, managing conservator, or parent have resided for at least 6 months, ending not more than 90 days preceding the date of the filing of the applicable petition, if the child's guardian, managing conservator, or parent is deceased at the time of the filing of the petition. And this repeal is going to be effective on SAPSRs filed on or after September 1, 2025. Continuing with HB 2350. This is going to amend Section 102.003A12 And it's going to include a relative or designated caregiver in the standing provisions for foster parents of a child placed by DFPS in the person's home for at least 12 months, ending not more than 90 days preceding the date of the filing of the suit, unless the child has been returned to the parent under 263.403, which is the monitor return, or the child has been placed with the parent and the suit by DFPS has been dismissed under Texas Family Code 263.401, which is the dismissal deadline statute. And it's going to apply only to a SAPSR filed on or after September 1, 2025. And just as a note, it was A12. It was renumbered as section 102.003.11 to conform with the repeal of the prior 11. So just wanted to point that out as well. Continuing with HB 2350, we're going to see an amendment to Family Code section 102.003A13. And it's going to expand standing to file suit if the child's parents are deceased at the time of the filing of the petition to another relative of the child related within the 4th degree of consanguinity. So it's going to expand the standing to that relative within the 4th degree of consanguinity. And here again, I'll just point out that 102.003A13 was renumbered as section 102.003.12, again, because of the repeal of 11, the former 11. And moving on to some of the intervention statutes, it also amends Family Code section 102.004A and B. And what this does is it expands standing to another relative of the child related within the 4th degree of consanguinity. And it provides that a grandparent or other relative or person may not file an original suit requesting possessory conservatorship, but may intervene in a pending suit under subsections B1 or B2 as applicable. This is going to apply only to a SAPSR filed on or after September 1, 2025. And next, we are going to actually be talking about B1. So 102.004 B1 is amended in that it allows a grandparent or other relative of the child within the 4th degree of consanguinity to intervene in a pending suit filed by a person with authority to do so under Texas Family Code Chapter 102, if there is satisfactory proof to the court that appointment of a parent as sole managing conservator or both parents as joint managing conservators would significantly impair the child's health or emotional development. This is going to apply only to a SAPSR filed on or after September 1, 2025. And now we're going to talk about B2 and B3 in Family Code 102.004. And this is going to be new language. And it provides that a non-relative with substantial past conduct may intervene in a pending suit affecting a child. But the court may not grant leave but the court may grant leave to intervene only if there is satisfactory proof that placing the child with one or both parents would significantly impair the child's physical health or emotional development, and each parent must consent to the intervention. It allows a foster parent, relative, or designated caregiver to intervene under this provision only if they have general standing to file under Texas Family Code 102.003A11. And I will mention that the A11 is what it is now, what it would be on September 1 after the repeal of the prior 11. So, and this is going to apply only to a SAPSR filed on or after September 1, 2025. We see additional changes to the standing provisions as a result of HB 2350 in Family Code Section 102005. This removes the following individuals from the standing provision in an original suit for termination and adoption. In other words, these two classes of individuals would, prior to September 1, 2025, would have had standing, and that is an adult who had actual possession and control of the child for 2 months within the 3-month period prior to the filing, and an adult the court finds to have had substantial past contact with the child. So these category of individuals after September 1, 2025 would no longer have standing to file an original suit for termination and adoption. And finally, as to HB 2350, it amends Family Code 102006C by broadening the category of relatives who are exempt from limitations on filing suits after termination of a parent-child relationship to a relative within that 4th degree of consanguinity of a former parent whose parent-child relationship with the child has been terminated by court order. Just keep in mind that it does retain 102006 does retain that 90-day limitation on filing suit. And this is going to apply only to a SAPSR filed on or after September 1, 2025. Moving on to HB 2495 by Representative Dutton. This has an effective date of September 1, 2025, and it amends Family Code Section 151.001A11, and it adds to existing rights and duties, the right of a parent to designate the school the child will attend and to enroll the child in that school, subject to any eligibility or admission requirements. And Family Code Section 153.1328 is also amended, and it provides that unless limited by court order, right, it adds to the existing rights and duties that a parent appointed as a managing conservator of a child has, and it adds the right to designate the school the child will attend and to enroll the child in that school, subject to any eligibility or admission requirements. And this is going to apply to a suit that is pending in a trial court on September 1, 2025, or filed on or after September 1, 2025. So this applies to a suit that is pending or filed. HB 2095 continues with an amendment to Family Code Section 153.37111. And this provides that unless limited by court order, again, it's going to add to those existing rights and duties, but this time for a non-parent appointed as a sole managing conservator of a child, that right to designate the school the child will attend and to enroll the child in the school, subject to eligibility or admission requirements. And this is also going to apply to a SAPSR that is pending or filed on or after September 1, 2025. Next, we'll move on to HB 2789 by Representative Frank. And this is going to have an effective date of September 1, 2025, except as otherwise noted. And as we go through that, we'll look at that. And this is going to add new language to Human Resources Code Section 42.0413. And it's going to provide that an SSCC is not required to obtain a child placing agency or CPA license to perform its DFPS contract duties. The licensing exception only applies to the SSCC, not to subcontractors or CPAs working under the SSCC. SSCCs must still comply with all laws and rules governing foster care, adoption, and child welfare services. Now, the rules adopted by the DFPS Commissioner to implement the section must ensure that the SSCCs operate in a manner that continues to prioritize the safety, and well-being of children in the foster care system. HB 2789 continues with a repeal of Human Resources Code sections 42.043B and 42.043(1)B. And what it does is it removes that requirement for tuberculosis testing for children at certain ages, and it repeals the requirement for daycare centers to maintain inspection-ready vision or hearing screening records. It amends Human Resources Code sections 42.049A and 42.049(5) in that it reduces liability insurance minimum from $300,000 to $100,000 per occurrence, and it lowers coverage required for listed family homes from $300,000 to $100,000 per occurrence, and it eliminates annual proof of insurance filing requirements. So these are some liability insurance and other types of changes. And these liability insurance changes take effect on January 1 of 2026. HB 2789 also amends Human Resources Code section 42.051B in that it extends the period during which an initial license for certain state-regulated facilities, including child care facilities, child placing agencies, and continuum of care residential operations, is valid from 6 months from the date of issuance to 12 months from that date. It amends Human Resources Code 42.068 by removing provisions specifying the locations at which each general residential operation operating as a residential treatment center must post no trespassing notices, and removes provisions specifying certain requirements regarding the content and format of those notices. It also amends Human Resources Code section 43.004A and B, and it replaces specific degree experience requirements for child care administrators or child placing agency administrators, and it requires an experiential or educational equivalent to a bachelor's degree in social work, child development, or similar field. Human Resources Code 43.009E is also amended, and it states that if a license is expired for longer than 90 days but less than 1 year, it decreases the cost of renewing the license from 2 times to 1.5 times the required renewal fee. So that has to do with the late renewal penalty. And the DFPS commissioner must adopt rules necessary for implementation of HB 2789 no later than December 1st of 2025. Moving on to HB 2809 by Representative Rose. And this has an effective date of September 1, 2025. And it amends Family Code section 264.017B. And in DFPS annual report update, it moves that deadline from February to December of each year and adds the number of suicide attempts by children in DFPS conservatorship to the required data elements in that DFPS annual report. And then it also amends Family Code section 264.018A4 in that it adds a suicide attempt to the definition of significant change in medical condition for those required notifications that we talked about earlier. HB 3181 by Representative Dutton with an effective date of September 1, 2025. It adds new language to Family Code section 156.107. And what it does is it allows courts to modify custody or visitation if a conservator has 3 or more contempt findings for denying possession or access. These findings constitute a material and substantial change that would justify a modification, and it applies to a modification that is pending in a court or filed after September 1, 2025. So it's pending or filed. It also amends Family Code Section 157.165 in that it prohibits courts from placing the respondent on community supervision and suspending commitment if the respondent is in contempt of court for the failure or refusal to obey an order for possession of or access to a child, and has previously been found in contempt of court at least 3 times for the failure or refusal to obey an order for possession of or access to a child. And this is going to apply to a SAPSR that is pending in a trial court on September 1, 2025, or one that is filed on or after September 1, 2025. HB 3181 continues with new language added to Family Code Section 157.167E, and it eliminates judicial discretion to waive attorney's fees and costs in enforcement cases if the respondent has 3 or more contempt findings for denying court-ordered possession or access. And this is going to apply only to enforcement orders rendered on or after September 1, 2025. It also amends and adds new language to Family Code Section 157.168. And it's going to require courts, unless good cause is shown, to award makeup time for missed possession or access. And for individuals found in contempt 3 or more times for such denials, it adds the requirement that the compensatory time be twice the duration of the periods of possession and access that were denied. And this applies to a SAPSR that is pending or filed on or after September 1, 2025. HB 3597 by Representative Hicklin, with an effective date of September 1, 2025, amends Human Resources Code Section 42.0461A, and it raises the population threshold for requiring a public hearing before issuing or expanding a license for certain child care residential operations. So from counties with fewer than 300,000 people to those with fewer than 500,000. And it updates terminology to reflect the transition from the department to HHSC. HB 3783 by Representative Hull, with an effective date of June 20th, 2025, amends Family Code 153.010A1C, and it requires mental health professionals providing court-ordered counseling in a case where there is conflict in resolving an issue of conservatorship or possession or access to the child to have training in the dynamics of family violence if the court deems it relevant. And it's going to apply to a SAPSR that is pending or filed on or after June 20th, 2025. So it's already effective. This change in law constitutes a material and substantial change of circumstances for purposes of a modification. HB 3783 also adds new language to Family Code Section 153.010C, and what it provides is that if credible evidence of family violence or sexual abuse is presented, it's going to prohibit a court from ordering joint counseling between the victim and perpetrator or requiring the victim to pay for counseling. And this, again, is going to apply to a SAPSR that is pending or filed on or after June 20th, 2025. It is a material and substantial change of circumstances that would warrant or justify a modification. HB 3783 finally adds new language to Family Code Section 153.1010D, in that it prohibits a court from ordering a party to participate in counseling that involves or requires any of the following: isolation of the child from their family, school, religious, or community support system. For example, blocking contact with a parent or other family members, out of state or extended overnight stays, even with a parent or family member, transporting the child under coercive or unsafe conditions, such as by force or threat, changes to visitation possession schedules outside of the court's authority, or use of force, threats, coercion, or verbal abuse directed at the child during the counseling. Again, this is going to apply to a suit that is pending or is filed after June 20th. It's a material and substantial change of circumstances that would certainly justify a modification. Next, we're going to look at HB 4121 by Representative Aisha Davis, and this has an effective date of September 1, 2025. And this is going to amend Family Code Section 264.155A, and then it's going to require that a contract with an SEC to provide community-based services in a catchment area must include that DFPS must implement formal measures to ensure the contractor is delivering high-quality service, including quality improvement plans, financial interventions, and other appropriate interventions or restrictions. And this is going to apply only to a contract entered into or amended, modified, renewed, or extended on or after September 1, 2025. HB 4377 by Representative Villalobos with an effective date of September 1, 2025 is going to amend the Human Resources Code, Section 40.084A, B, and C, and add some new language. And it's going to define terms like DNA, genetic information, genetic material, genetic test, and testing laboratory. And it's going to require that DFPS and testing labs used by DFPS promptly destroy genetic material and delete genetic information once the purpose of the genetic test is fulfilled. DFPS must retain the genetic test results, which remain confidential under existing law. There it is, Human Resource Code, Section 40.005. And all genetic material and information must be destroyed or deleted by January 1, 2026. HB 4466 by Representative Hicklin with an effective date of September 1, 2025, amends Health and Safety Code Section 191.0046, and this is going to require the state registrar or local registrar or county clerk on the request of a county or child welfare board to issue without a fee a certified copy of a birth record to the county or board if the request is related to a SAPSR filed by a governmental entity under Title V of the Texas Family Code, Subtitle E. HB 4655 by Representative Hull with an effective date of September 1, 2025, it's going to amend the Family Code Chapter 264.121A-21, and it's going to add to the requirements for PAL, experiential life skills training, and it's going to include instruction on like information about different like credit scores and credit reporting agencies, the risks of payday loans, an explanation of interest rates and users' interest, identifying and avoiding financial scams, and opening and using a bank account and creating a balanced budget. Now, Family Code Section 264.121A-22 was amended, and what it does is for youth who are 17 years of age or older, it adds to the PAL requirements to include instruction on financing a motor vehicle, including information about the types of financing that's available for those purchases and the risks of subprime and buy here, pay here motor vehicle loans. It both amends and adds new language to Family Code Section 264.121I. J is the new language, and it's going to add that requirement for DFPS to review a common rental contract with the youth and ensure that the youth possesses all the documentation required to obtain rental housing. And it requires DFPS to ensure that the transition plan for each youth 16 years of age or older includes information about securing or transferring governmental assistance, including things such as Social Security benefits, veteran or service member benefits, SNAP, WIC, TANF, and housing assistance. HB 4795 by Representative Noble, with an effective date of September 1, 2025, is going to amend Family Code Section 155-101, and it removes the requirement that a request to the Vital Statistics Unit be made in writing. That's specifically for obtaining a CCEJ or getting that statement that there is no CCEJ, and it also specifies that DFPS can make that request. It's going to require the Vital Statistics Unit to use existing resources to establish an electronic process through which DFPS may request identification of the court of continuing jurisdiction. It also amends Family Code Section 160.422, and this is going to relate to those paternity registry searches. Again, and it requires VSU to use those resources that it has existing to establish an electronic process through which DFPS can request those. And it allows for a digitized or written signature rather than the prior requirement that the certificate of the results of the paternity registry search be signed. It's going to require the HHSC Executive Commissioner to adopt rules to implement as soon as practicable after the effective date. And it applies only to a request received by the Vital Statistics Unit on or after. It's going to be January 1, 2026. So HB 5149 by Representative Villalobos, with an effective date of September 1, 2025, is going to it's going to add new language to the Family Code, Section 264.131, and it's going to prohibit DFPS from collecting or using DNA samples from a child in its managing conservatorship for any purpose without the written consent of an adult having actual care, control, and possession of the child as the child's primary caregiver, or unless there is a court order. HB 5394 by Representative Rose, with an effective date of September 1, 2025, prohibits an SSCC or child placing agency from subjecting a relative or designated caregiver to any requirement other than that provided by law or DFPS or HHSC rule, or adopting any policies or procedures that are related to a relative or designated caregiver other than, again, those authorized by law or DFPS or HHSC rule. Now we're going to move on to some Senate bills. And we're going to look at SB 127 by Senator Hall, with an effective date of September 1, 2025. And what this does is it extends the statute of limitations for failure to report by professionals. And it's, for a state jail felony from within 3 years from the date of the commission of the offense, as provided generally for felonies, to within 4 years from the date of the offense was discovered, and for a Class A misdemeanor to within 3 years from the date the offense was discovered. And it does not apply if the prosecution of an offense becomes barred by limitations before the effective date. SB 207 by Senator Paxton, with an effective date of June 20th, 2025, it's already effective, amends the Education Code, 25.07b, and it requires school districts to excuse a student from attending school for a temporary absence due to a mental health care appointment. And it's going to apply beginning with the 2025-2026 school year. SB 226 by Senator West, with an effective date of September 1, 2025, adds new language to the Education Code, Section 25.001, C-3, and it allows a parent or guardian of a child who is the subject of a PCSP agreement to establish residency for purposes of admission into the school district. The parent has to provide a copy of a letter from DFPS that indicates that the child is the subject of a PCSP, and that the address of the child's residence during the PCSP is located within that district. And it's going to apply beginning with the 2025-2026 school year. Again, it adds new language to Family Code Section 264.902A-1. So for school age child, again, it's going to require DFPS because they have to provide that letter when a PCSP happens, and it's going to have to contain that language that that the child is in a PCSP, and that the child's residence for purposes of enrollment is within the geographic area in which the child or the children reside. And again, this is going to apply only to a PCSP agreement executed on or after September 1, 2025. SB 500 by Senator Sparks, with an effective date of September 1, 2025, amends Family Code Section 162.005B and C, and it's going to require DFPS or a licensed child placing agency or the child's parent or guardian to distribute the HESIC report as required by statute. And it's going to require DFPS to ensure that each licensing child placing agency, SSCC, or other person placing a child for adoption receives a copy of any portion of that HESIC prepared by DFPS not later than 45 days after the later of the date the child's primary permanency goal is changed to adoption, or the date the court renders an order terminating parental rights with regard to that child. SB 500 continues by amending and adding new language to Section 162.0062A and A-2 and A-3, and it includes confidential information other than the identity of the biological parents and any other person whose identity is confidential in information related to the history of the child, which a prospective adoptive parent of a child is entitled to examine. And it redacts that identifying information not only of biological parents, but also of biological siblings adopted by other families and their adoptive parents, and of course the individuals who report abuse and neglect, and persons protected under emergency infant care confidentiality laws. It's going to require prospective adoptive parents to sign a non-disclosure agreement before receiving the confidential information, and it's going to require DFPS or child placing agency to provide records within 90 days of the request. SB 513 by Senator Sparks, with an effective date of September 1, 2025. And what this is going to do is it adds new language to Family Code Sections 264.181-198. And this is a fairly big bill, so I invite you to read this if you have an interest. But what it does is it creates a pilot program for rural regions where DFPS requested but did not receive bids, proposals, or other applicable expressions of interest to implement community-based care. And it really targets small county areas with no successful CBC bids. And it envisions a partnership with DFPS and a local nonprofit or governmental entity, and it's really focused on locally driven services, prevention, foster care, adoption, and youth transition. It requires the formation of a community alliance for stakeholder input, and it allows flexible funding models. It includes data sharing, some oversight protocols, independent evaluation when reporting to the legislature, and the implementation is going to depend on available funding. And this is going to expire on September 1, 2031. SB 835 by Senator Paxton, with an effective date of September 1, 2025, is going to make changes to the Civil Practice and Remedies Code 129C-001, and it's also going to add new language to 129C-002, and it's going to define acts of sexual abuse to include specified forms of abuse under the Family Code and under the Penal Code. And what it does is it voids any confidentiality or non-disclosure provision in any agreement, in other words, NDAs, that prohibit disclosure of sexual abuse or related facts. And it allows parties to keep other parts of an agreement confidential, such as the settlement amounts. And it is going to apply retroactively to all agreements entered into before or after September 1, 2025, and enforcement is barred unless the party seeking to enforce such a clause obtains a final non-appealable declaratory judgment affirming its enforceability. SB 855 by Senator Sparks with an effective date of September 1, 2025, amends Family Code Section 266.0043 with new language, or actually it's not amendment, it's new language, and it allows court-authorized medical consenters that are not DFPS to assume financial responsibility for a child's medical or behavioral health care, including from out-of-network providers. So the consenters can enroll the child in a health insurance plan, and it provides that DFPS is not liable for the costs unless it's been specifically ordered by a court, does not limit a child's Medicaid access, affect parental rights, or restrict a court's ability to order DFPS to pay. It does require the medical consenter to notify the caseworker within 10 business days of any such care, and it requires that DFPS record that care in the child's health passport. Implementation may be delayed if a federal waiver or authorization is going to be required. SB 855 also adds new language to Government Code 540.0807, and essentially it just prohibits Medicaid managed care organizations from taking any adverse action to prevent or discourage a recipient from accessing health care as provided in the 266.0043, and mandates that managed care contracts include this requirement, but clarifies that the managed care organizations are not going to be liable for the cost of those services. And again, implementation could be delayed if a federal waiver or authorization is required. Senate Bill 888 by Senator Colkhurst, and this is going to have an effective date of September 1, 2025. And this is essentially provides a new language to the Government Code, Section 403.024C, and it allows the OAG to represent ADAs or ACAs or defend them if in situations where they're a defendant because of their position or because of the cause of action relates to the enforcement of a state statute. And so this is going to apply only to a court action filed in federal court on or after September 1, 2025. Senate Bill 1141 by Senator Miles with an effective date of September 1, 2025 adds new language to Family Code 262/2011, and it's basically going to require the court to confirm in writing and in open court that before interviewing an alleged perpetrator, the department provided the person, the AP, with information regarding their right to create an audio or video recording of the interview and request an administrative review. DFPS, and they have to confirm that DFPS provided that person with the information related to investigation procedure and child placement resources upon first contact with the AP after initiating an investigation of a parent or other person having legal custody of a child. And this is going to apply only to a SAPSR filed on or after September 1, 2025. Senate Bill 1188 by Senator Colkhurst with an effective date of September 1, 2025 adds new language to the Health and Safety Code, Section 183.006, and it just requires covered entities to ensure that their electronic health records provide immediate, complete, and unrestricted access to a minor's medical records for the minor's parent, managing conservator, or guardian, unless there's limited by some state or federal law or some court order. And it's going to apply to minors age 17 and under who have not been legally emancipated. The bill has additional provisions, and I encourage you to look at the bill for additional citations. SB 1398 also by Senator Colkhurst with an effective date of September 1, 2025 is going to amend Family Code Section 262.4013, and it's going to expand the definition of family preservation services to include those services under the Family First Prevention Services Act and services under the Title IV estate plan. And it's going to include a member of a household who is subject to court-ordered services. SB 1398 is also going to amend Family Code Section 262.4014 411C, and it's going to remove that requirement that a parent who obtains family preservation services from a provider selected by that parent is responsible for the cost of those services. So it's going to clarify that the responsibility to pay for the cost of services selected by a person applies to a member of a household who is not a parent. And so we're going to see that same thing in Family Code Section 264-2031B, which was amended to kind of clarify that a parent is not going to be responsible to pay for services that they select during a court-ordered services case. All right, SB 1398 continues. And it's going to amend Family Code Section 263-0022A and B with new language. It's going to provide new language. And it defines temporary emergency supervision as supervision and care provided by DFPS or an SSCC for a child without placement for whom DFPS has been appointed as the temporary or permanent managing conservator. Now, it's going to prohibit DFPS or an SSCC from advocating for and a court from rendering an order placing a child in temporary emergency supervision if an appropriate placement is available. DFPS or an SSCC may not consider a child's refusal to stay in placement in determining whether the placement is appropriate. And this is going to apply to a placement review hearing of a child, regardless of the date on which DFPS is named the child's managing conservator. Going along with that and related to that is the new language that's been added to Family Code Section 263.0022C, which is if before a court can order this temporary emergency supervision for a child, DFPS or the SSCC have to submit a report to the court with information related to the type of placement, the location of the placement, of each attempted placement, right? The date DFPS or the SSCC contacted the placement, and the reasons DFPS or the SSCC determined the placement was not appropriate. And it's going to apply to a placement review hearing of a child, regardless of the date on which DFPS is named the managing conservator. And again, we're going to see this kind of expansion of case management services for SSCCs, and that's what we see here in the amendment to Family Code Section 262-152-2, which is going, again, expands the definition of case management, and it's going to now include pre-adoption and post-adopt assistance, services for children in the conservatorship of DFPS who must transition to independent living, and services related to family reunification, including to support that monitored return. And it applies to a contract with an SCCC entered into or amended on or after the effective date. Again, we see here new language to Family Code Section 264-1526, which is going to define family preservation services like we talked about earlier, and it's going to specify that it is services that are provided to the family of a child who is a candidate for foster care or to prevent or eliminate the need for removal, a pregnant or parenting foster youth, or a member of a household that is subject to an order rendered pursuant to 264-203, which is the court-ordered services or required participation section of the Family Code. And it, again, applies only to a contract with an SCCC entered into or amended on or after the effective date. SB 1398 continues with an amendment to Family Code 264-158A and B, and this is a really big bill. So again, I encourage you to look at it as we kind of quickly go through all of these provisions. But the main takeaway is that for here is that new contracts or amended contracts with an SCCC are going to be including this FBSS moving forward. Family Code Section 264-153 was also amended, and it amends the CBC implementation plan developed and maintained by DFPS by removing certain specifications that the evaluation of each contractor's process and fiscal and qualitative outcomes is independent, and specifies that the implementation plan must include a plan for evaluating the continuous performance of each contractor and the community-based care system as a whole. And it also includes that requirement for DFPS to post certain information on its website related to the goals for implementing community-based care, and which includes performance measure data. It's also it also adds new language to Family Code Section 264.154D and E, and it's going to require DFPS to annually post on the DFPS website the lists of the SSCCs providing services and a description of each contractor's full corporate structure, including divisions and subsidies. And it requires SSCCs to provide that information to DFPS. It amends Family Code 264.155, and this really has to do with the transparencies of the SSCCs. It just updates certain contract requirements, requiring sequential plan, annual performance reviews, publishing in that annual report, community engagement plans, and then different types of things permitting a contract with an SSCC to include provisions that require faith-based foster parent recruitment programs. So I encourage you to look at the bill for additional citations. Next, we're going to look at SB 1404 by Senator West with an effective date of September 1, 2025. And this is going to add new language and amend 105.0016. And it requires parties protected by a court order to provide an email address for legal notices. Court clerks may use the state's e-filing systems to send those legal documents to those protected parties. And child support modifications cases are included in cases where notice is sufficient if it's sent to the party's most recent filed email, physical, or work address, and applies to SAPSers that are filed in a court, that are pending or filed on or after September 1, 2025. SB 1404 also adds new language regarding the payment of attorney's fees or expenses in a SAPSer. Likewise, Family Code Section 157.167A1, again, dealing with attorney's fees and court costs and enforcement actions. And I encourage you to look at those as well. So it just requires separate judgments is what that really does. Next, we'll look at SB 1558, and it is going to amend the Civil Practice and Remedies Code, and it's going to create basically, this has to do with the liability of the SSCCs and certain changes to that, and making providing different provisions establishing that. And so we're going to move forward very quickly. Again, this has to do with the liability of SSCCs and nonprofits. So I encourage you to look at SB 1558 if you're interested in things that have to do with the CBCs. SB 1558 amends Family Code Section 81012 and 85.026B with new language. And basically, this has to do with protective orders, and it relates to conflicts between a protective order and certain other orders, and to the transfer of protective orders. So as you're looking, there used to be issues as to what order would control when there's a protective order, and these provisions help to kind of align with that. And so if you look at that, this particular bill provides for those types of provisions, and we're moving on to get you guys done. We have a lot of bills to look at, and so I encourage you to take a look at the PowerPoint slide when you have a chance, and read the bills and familiarize yourself with them. And likewise, SB 1589 by Senator Hancock, again, has to do with those accountability measures between DFPS and an SSCC, and DFPS's ability to reclaim case management authority. SB 1923 has to do with modifications that can be filed for child support. And this is going to really include the ability to seek modification if there is an authorization agreement with under Chapter 34 with that person. And I'm going to pause here.
Thank you so much, Brenda. And that is our time today. We want to encourage all of our viewers to email any questions that we weren't able to get to in the Q&A that were answered in the live presentation. You can email those to us at children@txcourts.gov, and if we're able to, we'll send you a response. On behalf of the Children's Commission, we want to thank you, our viewers, for attending today's presentation. At the conclusion of the live webinar, please take a few moments to complete an anonymous 3-question survey. The State Bar has approved 1.5 hours of MCLE credit. The course has also been approved by the Texas Board of Legal Specialization for 1.5 hours of certification and recertification for attorneys and paralegals in the areas of child welfare law and family law. Individuals who are watching the replay of this course can contact cctraining@txcourts.gov for MCLE self-report information. As a reminder, you can register for our live webinars and access the replay of this webinar and all of the Children's Commission offerings and our replays for free on our on-demand training and MCLE page. Once again, thank you for this presentation and have a great rest of your day.